Hello, and a very warm welcome to everyone on this foggy day. Thank you for joining us today. We are delighted to have you with us for our webinar on Digital Personal Data Protection Rules 2025, Transforming Cybersecurity and Privacy Compliance in India. I'm Ishana Dubey, and I'll be your host for today's session. The workshop is designed to provide a clear, practical, and actionable understanding of India's DPDP rules 2025 and what organizations need to do to ensure compliance in this evolving regulatory landscape. Here's a quick snapshot of what we'll be covering. Introduction and context, overview of the DPDP Act and the 2025 rules, key updates introduced in the new 2025 rules, roles and obligations of fiduciaries, data processors, and consent managers, key operational requirements, governance and enforcement framework, strategic implications for businesses, roadmap to ensure compliance with the Act and its rules, how Cyber SRC helps you comply immediately. There will be an open forum. Just a second, I'm really very sorry. How Cyber SRC will help you comply immediately. Open forum will be there for Q&A and discussion. We are honored to have with us Suhasini ma'am and Atulya. We look forward to their valuable insights and practical perspectives on navigating the DPDPA 2025 and implementing effective privacy and compliance frameworks. But before we begin, there are a few housekeeping items I would like you to keep in mind. Please keep your microphone muted during the session, except if you have queries. Please feel free to post your questions in the chat box at any time, and we'll address them during the Q&A segment. We encourage you, same time, to actively engage and share your thoughts throughout the session. With that, let's begin the session. So, Hasni ma'am, over to you.
Thank you, Ishana, for the warm welcome. And hello, everyone. A very warm welcome to all of you, and thanks for joining us today. So, we'll be discussing about this talk of the town topic, DPDP Act, and now the rules are operational. So, we need to understand DPDP is not just a legal requirement, it fundamentally changes how organization uh, how they expect to be handled by the customers trust and how they want to be scaled up and how they are taking the accountability, right? So DPDP is you can say a business plus the regulatory risk, if you talk about it, not only the legal part. So today we'll be covering the key points under DPDP over the reading session, definitely. And we'll be covering the regulatory aspect, right? The controls, the demonstrable controls, not only the intent, but definitely how the controls needs to be uh, thought about with respect to any kind of organization sector, right? Fintechs and payments platform, they are definitely a high exposure entities, but definitely this DPDP, I mean, it actually is a talk of the town for every organization with respect to like how they are vulneralizing the data of the principals, right? How they are processing and what kind of personal data processing, nature of personal data, and what kind of risk can occur to the individuals. So it is open for all, forum open for all, and definitely we'll be having the we'll first discussing the evolution of the data privacy, then definitely we'll be having the reading session where Atulya will covering the key points under DPDP rules and some of them taken from the Act also, and we'll be talking about the how we can help you and making you ready for DPDP compliance, considering, right, you're assessing the gaps in the current security posture, the operational aspect, the legal aspect of it, and how we can support you in your journey. So let's have a glimpse over first, like what we are, how we are operating, and just a glimpse of our team. So Cyber SRC is a certain and STQC empaneled organization, and definitely we have the global presence, and we are operating since 2018 January. And since then, we are dealing with different industries, leaders, and helping them resolving their complex problems in the domains of cybersecurity, data governance, and now the new upcoming technologies, OT security, OT, IoT, and the AI assurance also. So we have challenged and we have successfully challenged the technological aspect and how they look, how the organizations look towards their security domains. And we have simplified their complex situations that they are facing. Also, our goal is to assist organizations that are globally under that comes under MSMEs, SMEs, and definitely the enterprises where they want their capabilities to be enhanced, specifically in the field of defense, risk, security operations, and also the regulatory compliances. We are backed by a very strong team, diverse and dynamic team that have a combined experience of 45 plus years under the belt. And not only that, we hold great certifications with respect to the team and with respect to the current technology and trends. So first we'll see like towards the first phase if we move we would like to understand and also definitely you as an audience would like to have a quick glimpse like how it evolved everything do though all we know that how it evolved but specifically a glimpse like how the era changes in last 40 decades so in the early days of computing, so privacy was not a law, it was just principles. And organizations began digitizing their informations and the concerns emerged with respect to that around the misuse and the over collection of the data. So it evolved, and OECD principles been introduced that covered data minimization, purpose limitation, transparency, and accountability. Definitely. And when we have moved in mid 1990s, so that actually gave us the highlight of how the EU Data Protection Directive came into picture, UK Data Protection Act came into picture, and the key shift that came, like that focuses on individual data rights, obligations on data controllers, cross-border data transfer rules, right? So when again we move to the era of between 2000 to 2010, so digital data exploded, right? Like anything, and breaches and misuse increased, forcing countries to definitely strengthen their privacy governance, and that's why global standards like HIPAA, PIPEDA, Australian Act, Privacy Act came into picture. Then definitely the GDPR that came up between 2015 to 2017, and that changes the global course, right? And they that completely reset the global expectations on data protection. Highlights that definitely GDPR have introduced the explicit consent, right to be forgotten, data portability, mandatory breach notification, and definitely the heavy penalties. And in the era of 2017-2025, inspired by the global trends, all of these GDPR, LGBT, PDPA, all these privacy came into the privacy fundamental, I mean, acts and the standards, they came into the picture that introduced the modern privacy laws. And also in India, we have been through the DPDP bill and Act came into picture in 2023, and now we are in 2025 with the rules. So, this is all about the overall data privacy and regulations journey from 1960s till now. And definitely DPDP also have evolved between 2000 till now, right? So starting from the IT Act in 2000, and that definitely legally recognized digital data and e-commerce. And then in 2008, the Section 43 introduced account that covers the accountability for data breaches and defines sensitive personal data. And then definitely the SPDI rules in 2011 that detail the requirements for consent, privacy policies, notices, user rights. Then we have moved towards the Supreme Court, where the Supreme Court declared the privacy as a fundamental right. And I mean, between 2019 to 2022, multiple uh, things were debated, right? And finally, in August 2023, DPDPA was passed, and with DPDPA rules notified in 2025. And now India has a modern digital first privacy uh, law, right? So that is a privacy framework India is operational with, and with said with that, we will start our journey in this webinar, like we have understood the evolution, and now we'll talk about certain key points where Atulya will walk through us about the DPDP rules, the key focus points that we need to consider as an organization, how we need to start with that, whatever the maximum thing we can cover in this session. So Atulya, over to you. Yeah, thank you.
Okay, thank you, Sahasni ma'am. So, good afternoon, everyone. I am Atulya Rajan, and I will be taking you through a quick reading session on the DPTP rules 2025, where my focus is to help you understand what has changed, what your organization must do now with respect to the DPTP rules publishment, and what risk and the penalties applies if any non-compliance, conformity occurs. So yeah, in today's quick reading session, we will be just covering all this. So let me just share my screen first, and we will be further moving on.
By the time Atulya is sharing the screen, let me know. Let me talk about this. Like after the reading session, definitely we'll be covering the phase-wise implementation plan, that how we can help you out in that. Uh, I mean, operationalizing all those controls in your organization, particularly.
Okay, so now we will be going through the DPDP rules 2025 document, which is published on 13th of November 2025, where this rule book is categorized into three sections. So these three sections we will be discussing, like what is current priority to be discussed in this webinar session. So in today's webinar, we will be less focusing on few rules like rule number 17 to 21, which talks about board setup and chairpersons and members appointment, and we will be more focused upon the rule number 1, 2, And we will be talking about rule number 4 and rule number 1, 3, 5 to 16, 22, and 33. So I had just, for a better understanding, I had highlighted things here. So you can see these are the three categories in which we have divided the all 23 rules. So first it talks about the short title and commencement. That means how rules will be implemented in what timelines. Second talks about the definition, whatever terms are used here. Their definitions is precisely mentioned in the DPDP rule. Not only that, all the major definitions that are covered in DPDP Act and DPDP rules are majorly covered in the Act, which you can refer to understand any terminology. So, as I mentioned, from rule numbers 17, 18, 19, 20, 21, that talks about the board, which is Data Protection Board of India. It talks about its setup, how appointment of chairperson and members will be there. So this will be covering in a later part of the session or in next session. But currently our focus will be more on the category 2, where rules that shall come into force from first year after the date of publish. That means 13th of November 2025, the DPDP rule has been established. So within first year, it will be coming into force where we will be talking about the registration and the obligation of a consent manager. And then our next focus will be on the category number 3, which talks about the rules that shall come into force in 18 months after the date of publication. That means by exact 13th May 2027, below mentioned rules will be in force, implemented. Before that, we will be understanding how and what should be implemented, as it's a core compliance rule that talks about more of notices, security, breaches, and right of data principles, and obligations of consent manager, and responsibilities of data fiduciary and data processor. Right. So let's go back to the original documents. So as I mentioned, short title and commencement that talks about all these three categories. Then second definition, it talks about the definition which will be covered in this documentation. So act, techno-legal measures, and user account definition they have defined here, and all other relevant definition and terminologies that you want to refer, they have properly given in the DPDP Act. You can refer that there. So let's start with the first rule, third rule, which talks about notice given by data fiduciary to data principal. So here in this, yeah, so here in this, before we talk about it in detail, so before using someone's personal data fiduciary or any company must clearly and simply tell them what data it is it will be using, why it will be using, and how they can control it. So if you can see the notice should be covering these following points, which talk about notice must be very clear and standalone. That means the privacy rule or privacy notice which is published on the website or any consent app or any kind of contract annexure, it should be clearly mentioned that telling would that exactly tell what personal data is collected. Okay. And what kind of list of PI data a company should is collecting should be clearly listed. Like for example, name, email ID, phone number, address, any kind of ID details or locations. They should be clearly mentioning that. If we talk about what kind of purposes, so here the notice should be clearly defining what exactly and would tell exactly why the data is collected from the data principal for what purposes. Also, it should be clearly talking about tell the user how they can control their data if any data principal is giving their data to the data fiduciary or data processor. It should clearly highlight and they should have a clear control of their data. Like in the notice, it should be clearly explaining how to withdraw consent, explain how to exercise their rights, explain how to complain to the data protection board of India if there is any kind of challenge or any kind of fraud they have came under, or any kind of breach they have felt with respect to the consent manager or data fiduciary. So in the rule number 3, it's talk about how a notice should be published by a data fiduciary to the data principal, covering all these important and major points. Fourth rule talks about registration and obligation of a consent manager. Here, a consent manager is an organization which registered itself with the DPDP Act, which is Data Protection Board of India, where for the registration they have to provide certain, they have to pass or provide certain criteria list, which is mentioned in the part A of first schedule. If you want to know what kind of registration formalities or what kind of uh, criteria they must fit in, you should go in the part A of first schedule that is highlighted in this document on page number, yes, on page number 32, where it's talk about the condition for registration of consent manager. So here in first schedule, if we see, so it's talk about what kind of company is allowed to register as a consent manager. So here, if you any company want to registered as a consent manager, so they must be first an Indian company. Second, they must be capable. That means they should have a good technology, trained staff, enough resources so that they can properly run any consent from the data principal on the consent platform without failing. Then, third, the company must be financially healthy and well managed. Fourth, this talk about is the net worth of the company who is acting as a consent manager have a minimum net worth of 2 crores. Those company can only apply for that. And then it's talk about the company who is registering as consent manager. They should have a clear business plan which talks about real business model. They should have a good expected customer list. They should be able to survive long term on long term for whatever services they are providing to the customer. And sixth, they talk about directors and the top management, about their reputational insight, that the people who are running the company as a consent manager, they should have a good reputation, and they should have record of fairness and integrity, because as you know, they are being the trusted by the users who are giving the consent. They have a very transparent and clear background and reputation who is acting as a consent manager organization. Next, we talk about is the company's legal documentation must be logged in DPDP duties. That means the company's MOA and AU must clearly define and clearly say that it will follow all the consent manager rules. It will avoid conflict of interest with respect to the obligation they have to follow. And these rules cannot be changed if any kind of modification or any kind of change is required. They must ensure, and those rules mentioned in the MOA or AOA, they should be changed only after the board approval. And here the board approval we are talking about is DBBI, which is Data Protection Board of India. After their approval only, any certain rule companies in companies MOA and AOA should be changed or modified. Eight they're talking about is a company should be always be working for users benefit. That means it should be working in the interest of data principle, ensuring there is no hidden agenda, no dark pattern, or strict or forced consent from the data principle from which he is taking the consent. And ninth is talk about the independent certificate, which is mandatory, as you know, as they are providing a platform for the consent manager. So they are providing the platform there for the data principal, data fiduciary, and the data processor. It is very important that an independent auditor must confirm that a platform they are providing for the consent to the data principal It's secure, and user can easily give, see, and withdraw his sentence from that platform. It follows, and adheres to the DPDP standard issued by the board. Here, board is DPPI. Also, it talks about that the controls and processes. Sorry, the control here we are talking about B point, controls and processes certification. That means the company must also provide proofs that they have proper, secure, controlled and established in the organization. Proper policies and procedures are followed. Proper governance structure is there to meet the transparency obligation that has been precisely mentioned in the DPDP Act and the DPDP rule, to ensure that yes, they comply to the all requirement and adhere to all requirement of DPDP Act and rule. So here, as per mentioned in the part A of part A, consider conditions for registering of a consent manager. A consent manager should be applicable to all these points in order to register themselves as a consent manager. So second, same in the above context, they also talk about the part B, obligations of the consent manager. Here in the obligations of the consent manager, what they talk about is, once they are approved as a consent manager, what should be their key obligations, how should they behave. So their priority must be, first, the consent manager must allow the users to give consent to the company, either directly or through any trusted company. All right, the consent manager should be able to provide a platform where the data principal, data fiduciary can be onboarded, and they can further provide the consent to the data fiduciary for processing of the data for the specific purpose for which the individual has given his data for the processing. And second, consent management must not read the data. Here we talks about is the, even even if data is passed through its platform, the whatever the platform the consent manager has provided, if the data principal is sharing the data, the consent manager must not be able to see or read that data provided by the data principal. Third, it talks about the data must be kept detailed. The consent manager must keep detailed records of the uh, personal data that has been shared as consent. That means the platform where the data principal or an individual is sharing its data, it must be stored, recorded. For example, the platform must store records of the consent given, or any consent is denied by the data principal for any specific purpose, that should be also recorded. And consent withdrawal, if they have withdrawn any consent, that should also be recorded, and notice shown to the user. The notice, whatever is issued by the data principal, that should be clearly visible, and that should be recorded there. And which company the is receiving the data of the data principal, that should also be recorded and maintained there. So next thing we talk about is the fourth point, the consent manager must ensure that user must be able to access services through a proper website. Yeah. So here we have covered, about the giving and denying and withdrawing of the consent, and proper notice proceeding should be there. And if any data fiduciary is provided, taking the consent or PIR data of any data principal, it should be clear purposes and all should be defined. So in this two paras, this whole has been covered. And if we talk about the consent manager should ensure that there should be a proper website or application for users, so that the user must be able to access any services through a website or the mobile application that is offered as a platform by the consent manager. And consent manager must ensure and should understand its responsibility, that that organization cannot outsource its responsibility to a subsidiary company. The consent manager cannot hand over its duties for which he is approved from the DPBI board to any other company. All those obligations that must be done itself by the consent manager. There cannot be any sort of transfer of duties to any other concerned company or subsidiary company. And then next is the consent manager shall be have a reasonable security a safeguard to prevent PII data breach. That's talk about the consent manager, properly protect the data and consent record from hacking, leaking, or misuse. So there should be proper controls, proper audit, proper assessment should be done, proper mechanism should be there at the consent manager's end. And then it's talk about 8 point, which is the consent manager must act in the user's benefit interest. That means the consent manager must always act like a trusted guardian, put the user who is the data principal first, and never misuse its trust. Also, it must avoid any kind of conflict of interest with any the organization or any company. That means the consent manager must stay neutral and not favor any certain company or be influenced by data using company in any certain way. And the as the here it is mentioned, the in the point number 10, I am clearly defining that the director must also avoid conflict of interest. That means any top person who is acting as a top stakeholder or management, or a person who is is a consent manager, or acting in a consent manager organization, must not have any kind of share, must not hold any position, must not have any financial interest in the company who is processing the data, who is collecting the data. And they should be transparent and just avoid any kind of conflict of interest with respect to their roles and responsibilities. The 11th point talks about that they should be they must publicly disclose ownership and control. That means the consent manager must openly publish who owns the company, who runs the company, what are the who are the major stakeholders, and link with other companies. The whosoever is acting as a consent manager, they should be transparently define the overall picture, vision of the company, and what services and business they are serving, without any kind of hidden loopholes or any kind of misin- uh, misuse intention. Also, the 12th point, it talks about as a consent manager, they have a very effective audit mechanism. That means the consent manager must ensure the service they are providing with respect to the platform, they should ensure that they have a basic audit mechanism. To, for example, they should be properly conducting the internal audit, external audit. They should ensure that they are have check their security processes and compliance they are in place, and submit report to the board when asked. So they should comply with all the laws they are applicable on them. They should comply with the DPDP rule and act. Accordingly, they have to process all the data with respect to DPDP Act and rule. They should properly conduct a DPIM, that is, they should DPI, that is data protection impact assessment, and eventually they should be sharing the reports to the DPDI board for compliance purpose. Also, if we talk about the control of the consent manager organization, they cannot sell or merge their company without approval, since they have to, they are obliged to handle the role of consent manager independently. So any change or any sort of activity outsourcing, that cannot be done until unless it's approved by the board, that is DPBI board. So the consent manager cannot sell its company, cannot merge its company, cannot change controls of its company with respect to the service they are providing without prior approval from the data protection board. So, in the obligation of the consent manager, these are the point we are covering, and that with respect to DPDP rule needs to be covered. So let's talk about the next point. So these part A and part B of schedule first has been covered in the registration and obligation of the consent manager. Next we talk about is processing of the personal data for provisioning and issuance of subsidiary benefit services, certification, license, or permits of the state or it interventions. So here, if we talk, yeah. So here, if we talk, This talks about if we are processing the PII data, personal data of the data principal. So we have to adhere to the rules that are clearly defined in the Schedule 2. So here you can see that in Schedule 2 on page number, yeah, on page number 34, they have precisely mentioned the standard for processing of personal data by state and its intimate list under the Clause B of Section 7, and for processing of PII data necessary for the purpose specified in Clause B of subsection 7, subsections 2 of Section 17. So here it talks about that. Yeah, so here it's clearly talk about that if any kind of personal data is processed for any sort of subsidiary benefits, licensing or certification, or any sort of service which is funded by the public money. So in that, the data, when they're processing the data, it should be processing the data in a very lawful manner, lawful purpose only, and minimum data should be collected with response to the the requirement or purposes they are processing the data for the state or the government subsidiary. Third, they're talking about the data should be accurately processed, the processing should be complete, and it should be consistent, and there should be a proper retention, as PIR data should be retained in a proper manner as per the purpose served. Once the purpose is served for the processing of personal data, it should be erased, or if that organization is complied to any regulatory body or any law of India as per the retention period defined by the law of India or any regulatory body which is applicable on them, they should retain that data as per that timeline. Also, there should be a reasonable security safeguard to prevent any kind of personal data breach. Here they are talking about there should be proper mechanism, audit, assessment of their platform and services, and proper addressing to the complaint that the principal data principle is highlighting, to ensure that the overall process of the consent manager or the platform where the consent is given by the data principal to the data fiduciary or data processor is safeguarded. Here, same in this point number G, they have clearly mentioned if any kind of query the data principal have and they want to question or discuss anything. So data fiduciary, either they have to address to those questions or queries of the data principal, or they should properly give a business contact information where the data principal, any individual can contact that person and let its query and complaints resolved. Second, there should be a proper website or an application that data fiduciary and data principal should be provided, where the data principal can exercise his or her right on a proper platform. Third, it talks about that data, that whatever the processing of data is happening, it should be carried in such a manner that it should comply with the regulatory requirement as per issued by the Indian government. If there is, they are processing the PII data, and if any kind of applicable law is there with respect to the um, government or DPDP Act or any other regulatory bodies, they should comply with that. And as per the law, they should be adhering to those policies and guidelines given by the Indian government or the law. So here in this section, as per section 2, schedule 2, it's clearly defined how the data should be processed with respect to personal data processed by government and its instrumentally. Next we talk about is section number 6. Yeah, which talks about reasonable security safeguard. Here it talks about is any data fiduciary or data processor who is handling the personal data of data principal. They should ensure that there is they have security measures in place Organization must, implement proper encryption, proper masking, and tokenization properly is there. There should be second, proper access control is defined with respect to the data processed by the data fiduciary on the computer resources wherever they are processing the data, on how whichever devices they are processing the data. That devices environment ecosystem must have a proper access control. Then all the activities there that has been performed or with respect to the access or for the visibility, proper, there should be, activity log maintained. There should be properly monitoring and review part should be there to ensure that there is no unauthorized access. And there should be a proper investigation and remediation mechanism defined. If any kind of, unauthorized access occur, there should be a proper plan of action be should be there. And if any kind of, there is confidentiality, integrity, or availability breach happens, there should be ensure that there should be a proper backup of the personal data. They should properly define a data backup system, data backup server, where in time of breach of any sort of confidentiality, integrity, or availability breach, they should recover the data, and the platform where they're processing the data should be available. Then next is talk about retention period. It says that, specifically if any kind of, unauthorized access, for enabling the detection of any kind of unauthorized access, the data consent manager and should ensure, and the data fiduciary should ensure there is a proper retention of all the logs, all the, what we say, return all the logs, all the associated evidences and data should be properly maintained for 1 year, so that if there is any kind of unauthorized access, they can track down that, and they can track the event if there is any kind of compromise is there, or if there is, any law with like talks about the data retention should be, for n number of years, for 2 5 6, they should adhere to that if that law or that regulatory requirement is applicable on the organization. Also, next part is, it talks about the appropriate provisioning in the contract. So whatever contract is signed between the data fiduciary and the data processor, clear security safeguard provision should be defined in the contract in case of any kind of breach, any kind of security mishap, what kind of communication, what kind of, plan of action that will be there, that a data fiduciary will follow or the data processor will follow with respect to the contract they will be signing. So in that contract everything will precisely defined as per the contract or the legal requirement. Also, appropriate technical and operational measure, it talks about there should be proper technical measures, controls, and there should be proper organization controls to ensure that the overall mechanism, the overall processing of the data is done in a secure environment and continual improvements is maintained. Next, it talks about intimation of the personal data breach. So in this they talk about two things. One, if any sort of data breach happen, how a data fiduciary should be, immediately informing the data principal. And second thing, if in any kind of data breach is happening, how they have to immediately inform the DPBI, that is board, of that personal data breach. So here they talk about that a very clear description while, reporting any kind of personal data breach to the affected data principal. They should ensure that there is a proper description of the breach, including its nature, extension, and time of its occurrence. Second, the consequence related to her that will likely to arrive for due to the breach. And third, the measure implemented, what measure the data fiduciary has implemented to ensure that there is a proper mitigation of that risk, and the safe measure that she or may have to take to protect her interest, that should be clearly communicated and discussed. And there should be a proper business contact defined by the data fiduciary if any time any data principal or individual want to connect to the data fiduciary on the breach. Same way, the data fiduciary, as described earlier, they should be, immediately informing the board, or within the 72 hours it should be clearly informed to the DPBI board that so and so breach has happened, and in that breach they should be highlighting the following things, that is updated and detailed information with respect to the breach, and the board fact related to the event, and circumstances and reasons leading to that breach, overall background root cause for that breach, and what measure they have implemented to mitigate that risk, any kind of finding, if they have highlight, triggered, or they have came knowing about a person who is involved in that breach, if they have figured out that, they have to be clearly define, communicating that as well, and remedial measure they have taken or defined to prevent such actions in the future. And also the data fiduciary must ensure that when they are providing the report to the DPBI board, they should include a report which talks about how they inform the affected data principal about the data breach incident. So a report specific to that also needed to be included in the reporting by the data fiduciary to the DPBI board. So now the next is about the 8 number rule, which talks about time period for specific purposes to be deemed. Here they talk about a data fiduciary need to erase the data. They has to erase the data of the data principal once the purpose of the data collection has been resolved. Once the purpose has been served, the data fiduciary need to erase the data, purge the data of the data principal after fairly proper communication to them. So here they talk about is the core rule for this rule is data, they should delete the data once the purpose is solved, and they should inform the data principal or the user 48 hours before deleting that data, that they are going to delete the data since the purpose has been solved for which they have took the data. And in special in and also they should ensure that with respect to this point, that they should be maintaining, if with respect to the point number 1 and point number 2, the data fiduciary shall retain the data of the PIR data on the behalf of data fiduciary, and they she should ensure that they have associated traffic and log maintained for at least 1 year from the if they have processed the data of data principal. They should ensure one thing, that they have a minimum period of 1 year. They should be maintaining the data logs of the data fiduciary, sorry, data principal. Also, if some organization with respect to different industry sectors, they have specified how long they can retain the data for some industries. For example, if they have clear, if you can see, they have clearly mentioned in seventh schedule, they have precisely mentioned about few data fiduciary organization for how long they can maintain the data, and after what time period they have to erase the data. So if we see the section 7 in this document, section, not section 7, seventh schedule of this document, it's clearly defined. Yeah, yes, section 7. No, sorry, it must be section, right, it is the section number 3. Yeah, in section number 3, it is clearly defined if a data fiduciary is a e-commerce organization and it have less than 2 crores of the registered users, so they should ensure that the data they are maintaining, uh, such kind of large platform must erase the data after the use after 3 years. If you are an e-commerce company and you have less than 2 crores of the registered user, then you should ensure that the data is must erase after 3 years. Same way, if your data fiduciary is a online gaming intermediate organization or intermediary, they should ensure that such large platform must erase unused data after 3 years. So after serving the purpose of taking collecting the data, if the data is unused, then they should ensure that within after 3 years they should be deleting that data. Same way, data fiduciary who is a social media intermediary, they also should ensure that they should delete the data if it is unused after 3 years. So they have, for these three specific industries, they have mentioned a timeline of 3 years. So other than that, they have clearly mentioned after the purpose has been served, they should be maintaining a log of 1 year associated input they have to store for 1 year, and then after taking the consent from or informing the data principal 48 hours before, they can erase the data. So now the next we will be talking about is, okay, contact information of the person to answer. As I told you, the data fiduciary must, on the website or on its application, clearly communicate and define a contact person who will be, taking all the queries and all the complaints, or any kind of queries or question the data principal have. So they should define, contact person of, you can say, a data principal officer, or as per their organization, who is relevant to take that role other than the data principal officer. They should defining their contacts like email id, company ids, where they can contact on that with the dpo or the other position that is taking care of that responsibility, any responsible officer, for the communication of their rights or complaints or any kind of question query they have. So now here we talk about next year verify consent for processing of personal data of child. As you are aware, a child cannot process its data, personal data, or any kind of platform. So there is a proper defined verifiable consent that is defined with respect to that a child. There is a parent who should be clearly 18 years, 18 age or above, who can act as the legal guardian and who will act as a parents, who from whom the consent can be taken for a child. So it's strictly control this and strictly says that parents must be verified in terms of, we are talking about taking a consent for processing of a personal data of a child. Then for that parent, age verification is very much mandatory. And age verification, when they are doing, they should be ensuring that that adult should be above, the should have completed the age of 18 and or above. And when they are processing or verifying the age of that individual, they should be either doing it from the DigiLocker or any other authorized ID. This is allowed by the central government. So that sort of legal guardian or parents can only be a verifiable consent for the processing of any personal data of a child. There are some illustration examples they are given that you can go through uh, for your better understanding. So we will be moving forward as we have a very short time. So here also we talk about verifiable consent of the processing of personal data or who is disabled. And by law, it is clearly defined that consent should be only taken from a person which is defined as a guardian by the law of India, and that guardian must be verifying through court or any kind of designated authority. If a law court or designated authority is saying that he or she is the legal guardian of that disabled person, through that person, the consent of the personal data consent can be taken for the disabled person. So, with respect to law, they have clearly defined what kind of authority and under which act it is covered. You can go and check, lawfully which guardian under which act can be, covered for under this requirement. So here, yeah, so here are some exemptions we will be talking about. So there is a limited exemptions for a certain obligation which is applicable to processing of personal data with respect to child. In section 4, we can say fourth schedule of part A, below it's clearly mentioned what are the exceptions there. So there it's talk about that exemptions are allowed for the we will check the requirement in four schedule. So if you go to the fourth schedule here, Yeah. So, exemptions are allowed if a data fiduciary is a clinically established mental health or establishment of healthcare. So, exemptions are there for any kind of hospital, any kind of, healthcare professionals, or any kind of educational institute, schools, childcare, or any transport safety or health. There are exceptions allowed for sharing of the PII data of a child, since it's a uh, under this law it talks about there is a proper classification of data fiduciary, like under these categories there are exemptions given for processing of the PII data of a child, how they can condition it, and how they can ensure that on a minimum data requirement and safe and welfare of that individual, with the minimum requirement, how that personal data can be exempted from collection. Same way, if we talk about significant, next point is the significant data fiduciary. Yeah, additional obligations of the significant data fiduciary. Here it talks about like who is qualified. So even by notified by any government based any kind of data volume or sensitivity or risk. So it clearly says that a significant data figure shall once in every period of 12 months from the date on which it is notified as such, or in is included in the class of data federation notification as such under DPIA, that is data protection impact assessment and an audit to ensure effective. So there should be in every 12 years there should be a DPIM or an audit which needed to be performed to ensure that the what we say, yeah, there should be proper compliance to the requirement of DPDP Act or other law or regulatory requirement that is applicable on the significant data fiduciary. There should be a whatever report as per the not whatever report, the data protection impact assessment they are doing or the audit they are doing, that is timely submitted to the board. Here the board is Data Protection Board of India. It should be properly submitted to the board in a proper documented format. They should be highlighting all the, if there is any kind of compliance breach or any kind of conformity non-conformity, they should report that in an annual basis within 12 months. And there should be proper due diligence to verify that their technical measure including algorithm, okay, they should ensure that their right to data principle, tied to data principle, it ensure proper due diligence is done. Any kind of complaint or grievance is there, that is properly handled for the data principle. And they should ensure that that yes, no data should be shared outside of India without proper as per the law as per the law established by the central government or the DP uncovering under the DPDP Act. There should be no information or data that should be shared outside India. And it should under the law of government, it should be ensuring if there is a data sharing requirement is there, that should cover and that should follow law defined by DPDP Act. So right to data principle, it's talk about the right to data principle. They can exercise their right. They can access, correct, delete, and they report their grievance if their requirement is not fulfilled. If there is a mismanagement of their rights, if there is a mismanagement of their document or data or consent, in this they talk about the right they have to exercise, how they can exercise, and where they can actually report their issue, and to where they can report their grievance. And yeah, so here the company is obligated to easy access mechanism. If there is any kind of grievance and complaint that any kind of data principal have, that should be resolved in 90 days. That is the time period under which the grievance system should be completed if any kind of grievance is there for data principal. And yes, with respect to cross-border transfer, There is a cross border, data transfer is allowed, but also subject to the government restriction, with proper, as per the defined government rules and regulation and restriction, data can transfer with a specified restriction, and there should be certain countries and entity may be blocked where the data cannot be shared. So entities, data fiduciary should ensure that there is no such countries where the data is shared, and the countries are restricted by the government are not entertained. And next we talk about is exemption from the Act of Research, Archive and the Statistical Purpose, where it talk about okay, the processing of the personal data is allowed if safeguard is applied law for the lawful purpose, and minimum data of the if data principle can be processed, and there is an exemption on that if there is any kind of requirement with respect to the law that the data needed to be processed of any individual or any data principle, that can be done, and there is an exemption on that. For detailed understanding, you can check the section 2, section second schedule, where precisely it's mentioned how it can be done. You can go through and read here. They will be, it is clearly defined how they can, exemption is there for processing of personal data with respect to research work and everything. They have clearly mentioned here. So next here we talk about is the 17 one. Okay, as I told you, 17th appointment of chairperson and other members, 17, 18, 19, 20, 21. This talks about the board, which is board setup, which talks about DPPI board setup, how the appointment of the chairperson is done, how the appointment of other members is done, salary structures, functionality of the board, terms and condition of appointment. So this doesn't cover under our requirement of compliance. This covers under the board, so we need not to look into that. So next is talk about the appeal to the appellated tribunal, where it talks about there should be a proper digital file. The data fiduciary or the consent manager should be able to provide a proper platform. In that platform, they have the right, and the data principal have the right to digitally file all any kind of grievance they have, any kind of complaint they have against the data fiduciary or the consent manager. They can file that to the tribunal. And not only that, there's a minimum online fees they have to submit in order to process their complaint with the tribunal. And there's a natural um, justification, justice principle is there. So tribunal ensures that in the interest of data principle, for the right of the data principle, they will process the request of, or consider the request of the data principle. And if there is any kind of breach at the end of data fiduciary or data fiduciary or consent manager, proper actions will be taken under the law against the data fiduciary and consent manager. So they have clearly defined that as well. And calling for information from the data fiduciary or intermediary, the government can demand any kind of data with if there is any issue of national security or legal compliance or regulatory assessment for which the data is required for of any individual or data principal. The government has the power to seek that data from the data principal, sorry, data fiduciary or the consent manager without any obligation. So company may be prohibited from informing the user as well, sometimes if they have to disclose the personal data of the data principal to the government for some national security or legal compliance. So yeah, so these are the 23 controls that they have highlighted here. So we had covered, and not just that, these were the 23 controls we talked about. However, there is some legal penalties as well if we do not adhere to the DPDP Act and DPDP rule, which is clearly mentioned in the DPDP Act before. So I will be showcasing that. So here you can see if, yeah, so you can see here So in four tiers, it is defined the penalties and enforcement of non-compliance. So if some core obligation breach is happening, for example, the basic fundamental of DPDP Act or provision, for example, proper consent, notice, or data security or breach is not notified or informed, or proper consent or notification is not provided by the data fiduciary or the consent manager, so there is a penalty of up to 250 crores. And this is the penalty that has to pay. So for tier 2, if there is any kind of security failure, so any organization who is acting as a data fiduciary or a consent manager is acting, providing the platform, if they fail to comply with any compliances with respect to DPDP Act or regulatory requirement or law of government which is applicable to them, and they fail to have a reasonable security safeguard. So penalty is there of 200 crore, which will be applicable on them. And then violation, which with respect to fiduciary, if fiduciary duties are violated, for example, they fail the core, purpose of being a data fiduciary, and they, which includes the DPI, if they fail the DPI assessment or annual assessment, or there is any kind of, uh, algorithmic or any kind of failure in the due diligence, then the data fiduciary is have can face a penalty of 150 crore. Up to 150 crore they can face it. And last we talk about the notification failure. If any data fiduciary, data processor, or data fiduciary acting as a data processor or any concerned manager, if fails to notify the data principal about any breach, or they delay in notifying the breach to the DPBI board, then for that non-compliance, they can they can face a penalty of 125 crores. So starting from 125 up to 125 crores, they can face this penalty. These four tiers, they have defined the list of penalties in the DPDP Act, which you can refer in the DPDP Act clearly. So based on this, these penalties are applicable on them. So in this reading session, we just in briefly covered about all 23 acts and the penalties that will be enforced on a data fiduciary organization if they fail to comply with the requirement of DPDP Act. So from here, Ms. Vasni ma'am will take on the further session. So thank you.
Sure, Atulya. Thank you so much, Atulya, for this comprehensive reading session. And coming back to the agenda, like moving ahead with the agenda, we started with the evolution of the privacy, DPDP evolution, and now the in detail reading session of the DPDP Act and the rules. We will understand like what key requirements the organizations must focus on. Definitely, Atulya has covered it in detail. So we'll just talk about it a little and we'll move ahead like how we can help you to to be compliant with this DPDP and at least ready and start your journey with it. So for that, we need to understand like for every organization, data inventory and mapping is very much required because without inventory or without identifying what kind of data you're holding, right? So that would not be good for your organization's health. Like you will not might not be knowing the workflows, the type of data, right? So that a collective and comprehensive requirement of that data inventory and mapping is very much required. And definitely there are certain automated tools also that designs workflows and that will identify the PII of your PII data of your organization. So all those things are possible. The thing is like you need to understand the key focus areas, and then accordingly you can act. Definitely, if we talk about the purpose limitation and minimization, we have talked a lot about in the standard. So there must be principles aligned around your organization. The policies must be designed like that way, that how the data retention is planned, right? And definitely the consent management, how it is designed with respect to the act, clearly mentioned how data subject rights are being handled, right? How the accesses are being provided, how the correction and erasure actions have been taken with respect to the request, right? So all those things matter a lot for any organization. So proper policies and defining the automation journey if required, right, for any organization, how they want to go ahead with it. So it is possible with these focus areas. If you talk about definitely the security safeguards or the right house, your current security posture is right, how you are responding to the incidents, uh, definitely it plays a critical role, and also for an organization to identify themselves as a SDF, significant data fiduciary obligations or not. So all those things matter a lot because they need to decide that how they need to go ahead with the appointment of the DPO or establish a cross-functional privacy steering committee. So definitely organizations need to think about it. So common gaps like enterprises that they currently face, and also being in this field, we have identified that these are the areas where organizations need to work. The fragmented data landscape, obviously, because the things are very scattered, right? So the organizations need to work towards a centralization, right? If we have talked about the data inventory, right, they need to identify the blind spots in the visibility. Definitely, your risk register needs to be updated in terms of business, IT, technical risk, functional risk, right? So all those things needs to be properly aligned and mapped so that you can plan your security postures, and you can align your, operational risk with respect to the business risk. So those things are very important along with the legacy and system constraints like outdated technology stacks are being there in the organization that are actually incapable of enforcing data erasure and all the retention policies, the user rights at scale. So, it plays a, it actually, it is a triggering point for any organization to start with to work on how they can, I mean, move on with their legacy system, right? And definitely the vendor governance, which is uh, I mean, the a topic, a critical topic anytime, because the risk, the breaches that are happening with respect to the third party, right? They are actually very critical to understand, and also the remediation plan, response plan needs to be defined in that way, right? So proper third party contracts, and now the specific DPDP clauses, right? Indemnities, and how the obligations are need to be designed, right? So all those things need to be understood with respect to the DPDP now also, and also from the security aspect. Not moving in detail with respect to the consent flows and breach responses, we have already covered in this reading session. I'll straight away go to the roadmap, where how Cyber SRC supports you. Cyber SRC supports DPDP end to end, right, to consulting, advisory, actual enablement of the systems, right? We help you with, analysis of your consent frameworks, governing when, governance structure of the with respect to your vendors, readiness with respect to the breaches, and how you need to plan the responses, right? And also with respect to the SDF obligations wherever applicable. Our focus is not just compliance, but making DPDP practical, auditable, and business aligned. So DPDP, don't consider it as a project, but it is an ongoing governance. It is not a one-time project. It is an ongoing governance journey, like any other compliance framework is. And early action reduces definitely the regulatory risk, and it improves your customer trust and strengthens data discipline, definitely. And we recommend starting with a focused DPDP readiness assessment at least, so that you get to know that where you stand and what needs to be prioritized, right? Because there are timelines with respect to the implementations, and in actual overall you the organizations have 18 months, but there are certain things that needs to be immediately taken care of. Tools definitely we support like how organizations need to go ahead with the automation part with respect to any, I mean, identifying PII or designing the consent management, consent frameworks and designing the consents, forms, notices, right? So we help, we support the organization in that. And definitely from the legal aspect also, we have a hands on it and we have a team of experts who guide on the legal aspect also. And also, if you talk about the phase-wise journey, definitely I'll just brief you out how we'll start with that. Like I already said that we start with conducting the readiness assessment. Those three-phase journey we will identify in like in initial phase, we'll identify how your governance structure is, right? Inventories. We'll have some clarities around your environment with respect to your approach, business approach, and all those things. We will do the recurrence around it, and definitely in the next phase, we will help you out in the implementation, operationalization of your controls and integrating your processes, how you can minimize your gaps around it. Right? And definitely we'll give you the assurance, audit, and maturity in terms of like how we will do the validation, how we will give you the optimal solution, consultancy in optimal solutions, and how you can hold that compliance long term, right? So we give you that kind of assurance also, so that your organization is in a quite mature state with respect to this compliance framework. So definitely, in detail, little in detail, the core activities in these three phases. Definitely, phase one, we will covering the assessment and discovery, right? And detailed record of processing activities being created, consent management baselines will be set up, and audit current practices will be planned up. And definitely, we'll have a discussions to build the privacy steering committee with respect to your cross-functional representation, how it will be go ahead. We'll give you the guidance over it, how you can appoint, how you can design your committee, right? Covering all the aspects and designing and documentation awareness. Definitely the sessions, the training sessions within your organization so that the employees are also aware of the things in detail. Definitely the deployment priorities, how we'll go ahead with that. Once we have identified your environment, your approach, your alignment, your business alignment, right? Business vision. So we'll do that with respect to designing the controls, right? Considering the DSAR things in the mentioned in the DPDP, right? Data lifecycle management, how end-to-end data is being, I mean, collected, stored, used, right? So all those things will be considered. Third-party governance will be covering it, and how ready you are with respect to any incident. Definitely the third phase cover the validation audit part and how you can better optimize your I mean solutions in terms of I mean maturing your current security posture and how well you can sustain and do the ongoing governance smoothly, right? So critical success, just the call to action, like how the critical things can be monitored well. We can have a design matrix to monitor them. Definitely, we have, I mean, highlighted here certain important metrics that you can prepare for your organization. So, I mean, moving ahead with the session, like we are here where we have end to end how the from starting from the scratch till the end, how we can handhold you with respect to your DPDP readiness. So, definitely we are displaying our contacts details. You can contact our solution team and they can guide you more, solution technical team. So we'll be ending this session, but I would like we have 5 to 6 minutes more. So the forum is open for Q&A. So yeah, you can put your questions either on the chat box or you can ask anyways. Okay, so I could see like some of the external participants have been, I mean, they have joined us. So thank you all for joining us. So any questions, please go ahead. We are here, or otherwise you can contact our team. Uh, the phone numbers we have displayed up. Okay, so I think we are good to go, and thank you all of you for joining us. I mean, talk to you soon, and any queries, please reach out to us. Thank you so much.